case briefs, and so much more. LSData's got what you're looking for.
In 1891, the New York Court of Appeals heard the fascinating case of Hamer v. Sidway, which revolved around an unusual agreement between an uncle, William E. Story, and his nephew, William E. Story, II. The uncle promised his nephew $5,000 if he abstained from drinking alcohol, using tobacco, swearing, and playing cards or billiards for money until his 21st birthday. The nephew successfully fulfilled his part of the agreement and informed his uncle, who later passed away before delivering the promised $5,000. The nephew then sold his claim to the plaintiff, who sued the uncle's estate. The estate argued that there was no consideration to enforce the contract, but the court disagreed, stating, "A valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit accruing to the one party, or some forbearance, detriment, loss or responsibility given, suffered or undertaken by the other." Despite the estate's argument, the court affirmed that the promise made by the uncle and the consideration given by the nephew was sufficient to support the enforcement of the agreement. The nephew's promise to abstain from certain activities was considered sufficient consideration for an enforceable contract, even if the abstention primarily benefited him. The uncle's agreement was deemed valid because the nephew had voluntarily restricted his lawful freedoms. As a result, the court ruled in favor of the plaintiff, upholding the lower court's decision and compelling the estate to pay the promised $5,000.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.